All right, hi, welcome back. Attorney Steve Vondran, welcome to another exciting episode of Litigation Whiteboard. We are talking in this video about responses to a complaint, the various types of responses, and the sham pleading doctrine. I just love that word. I don't know why. It just feels good saying it, the sham pleading doctrine. All right, without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so we're here, and you know, when there's a complaint filed as a defendant's counsel, you have various options. One, if you're in federal court, you can file a motion to dismiss, what we call the 12B motion. There's lots of different grounds for filing the motions: jurisdiction, failure to state a claim, other things like that. In state court, and I'm going to be talking about California law in this court. That's where I practice. California law. So check your state. There's probably similar rules. But I want to talk about the sham pleading doctrine, some of the different responses to a complaint. Of course, somebody files a complaint, you can answer it. You can file a motion to dismiss it. Like I said, federal court. In state court, many times it's called a demur. I also practice out in Arizona. Their state court cases are motions to dismiss, similar to the federal court. So it really depends. Check on your state. But one of the things you can do is file what's called a motion to strike. And I put it over here, the MTS, the motion to strike. And under California law, we have CCP 436. And CCP means California Code of Civil Procedure. If you got that right, you're headed to the top of the class, especially you bar takers. Okay, so one of the options is to file a motion to strike the complaint in its entirety, part or all of it in its entirety. You can always strike scandalous, irrelevant material, but you can seek to strike. There is precedent in California anyway, and I have it right here, the Hendy versus Lossy case. There's your case citation, 54 Cal 3rd 723. But you can file a motion to strike the complaint. And I'm going to give you an example of how that may arise, okay? So say somebody files an original complaint and there's an employment contract attached to it. There's an arbitration clause and somebody's alleging, let's say, trade secret violation. And then for some reason, the defendant would point out, hey, there were no trade secrets, or hey, it's an arbitration clause. Why are you filing this in the state court? And there's an arbitration. You need to go to arbitration. Then the party says, well, wait a second here. They may be right. Why don't we get fancy and tricky? Why don't we file a voluntary dismissal, and then we'll file again. We'll refile right here, suppressing or omitting the employment agreement part of this, suppressing or omitting that, and say, well, let's try to maybe we won't allege the trade secret, or maybe we'll allege something else, but let's just eliminate that so the court doesn't see it, and then we'll try to go into state court anyway. Well, what about the arbitration clause? Aren't you being a little sneaky to the judge? Is this a fraud on the court? It's unethical fraud on the court. So dismissing something like an arbitration clause because you want to avoid a demur or get around a statute of limitations or get around a clear problem that's pointed out to you after you file. So doing these kinds of things and then refiling, this is the key, and then refiling the complaint. That is what we're talking about here. And then omitting this and then saying, hey, well, we'll just get rid of the arbitration clauses. We don't arbitrate. Haha. That's an example of how this sham pleading could pop up. You would argue the motion to strike the pleading because it's a sham pleading. It should be in arbitration. They just omitted this. Now they're not even telling you why. If you're going to be amending, and that's not even amendment of a complaint. This is refiling a brand new complaint, getting a new case number. Okay, so, and you may even mean that you're getting a new judge. So that's an example where, again, if you're going to change your facts, you want to explain why the facts have changed. Don't do things shady where the judge may not know what's going on. Because the opposing counsel, you're a good defense attorney, like myself, we're going to point these things out. We're going to find these things. And you may be judicially estopped because of these arguments that you're making here in your complaint. You could be judicially estopped. Another one I like is waiver. Is that if you are eliminating this cause of action and filing a new action, are you waiving any, let's say, employment claims that you might have or trade secret claims that you might have, for an example? So these are very important things. In a judicial estoppel, this is a great little term. Judicial estoppel basically says when you say something in federal court, state court, when you say something in a pleading, you're bound to it. Means you are estopped from claiming something different. Okay, so this is where this can come up. So a motion to strike. Now I have down here, just for you legal buffs, CCP, Code of Civil Procedure 472A as in apple. You are allowed to dismiss your case with prejudice, without prejudice. You're allowed to do that. You're also allowed to amend your complaint once before anybody answers. So if there's an answer, then you need to go seek leave of court to amend your complaint or do something. You can't just go amend it. You're circumventing the process by doing something like that. So I want you just to keep in mind, a motion to strike is a tool, CCP 436. You strike all or part of the complaint. In this case, the second one that was filed, if somebody pulls a stunt, I call it a stunt like that. But here you have the original complaint. You may have judicial estoppel. You may have waiver of claims. Look for that. You can dismiss once before an answer and amend your complaint as a matter of right before an answer. But if you're going to be changing things, omitting, suppressing, things like that, you should explain why certain things were omitted and why they're not at play anymore, let's say. Otherwise, you have motions to compel arbitration.